All right, let's do it. Hi, everyone. My name is Pooja Nair, and I'm here with my colleague and partner, Jeff Glassman. We're here today to talk to you about food, beverage, hospitality, and the internet. This is an industry debrief on what you need to know about the internet, essentially, in terms of regulations and laws that could apply, including consumer privacy, data security issues, and the ADA accessibility on the web and on your apps. We think that this is a very relevant presentation now, especially given that the pandemic has driven so much market activity for the industry online. Before we get started, I'm going to ask Jeff to tell you a little bit about our firm, Irwin, Cohen & Jessup.
Good, Pooja, thank you so much. Good morning, everyone. My name is Jeff Glassman. I am a member of Irwin, Cohen & Jessup's corporate department. The firm has been in Beverly Hills for probably the last 60 years. We're a mid-sized regional firm targeting mostly entrepreneurs, emerging growth, and lower middle market companies. It's a full-service law firm, corporate, intellectual property, real estate, litigation, and a variety of other practices, including intellectual property and others, that help us essentially be a one-stop shop for entrepreneurs that are launching new companies or growing existing companies. I've been at the firm for more than 10 years, and really the underlying philosophy that's driving the firm is long-term partnerships with our client base.
Thanks, Jeff. And my name is Pooja Nair. I'm the head of the firm's food, beverage, and hospitality practice group, which we just launched this year. The food and beverage and hospitality practice group is really designed to target all sectors of the industry. So our clients include restaurants, wineries, food manufacturers, manufacturers of consumer packaged goods, hotels, and anything kind of in that spectrum of food, beverage, and hospitality. So today we're talking specifically about food, beverage, hospitality, and the internet. Given the pandemic driving so much customer behavior online, even companies that have traditionally used word of mouth or have not really had much of an online presence are finding themselves needing to have a web presence and to use apps to connect with consumers. And that increased online activity comes with a lot of legal risk and a need to understand what the law is. There's also been an increased amount of data breaches in all industries, but specifically there have been several high-profile instances of data breaches affecting hotel groups and restaurant groups that we'll discuss later in the presentation. But because of these recent breaches, a huge focus has been consumer privacy. Consumers are aware that they are putting their data out there when they interact with companies, and they're very concerned about protecting that. And California specifically has been very focused on this issue. So the first part of our presentation, Jeff is going to talk about recent California laws that could affect your companies who are operating in California. And I'll let Jeff get started. If you have questions as we go forward, please use the Q&A button below at any time. And I'm going to be going back and forth with Jeff and asking questions as he's talking. But if you've got questions, I'll make sure to ask questions from the audience so we can keep this interactive in that way.
Good. Pooja, thank you. So I have become a privacy law evangelist. And in large part, the reason is the passage of the CCPA, the California Consumer Privacy Act. It has had a profound impact on a handful of companies. We are at the earliest stages of this law's existence. And in fact, on the California ballot, Prop 24 is essentially an amendment to the existing statute, the CCPA. So if it passes next week, within the next 2 years, we're going to have a bigger and more robust version of the CCPA. And so as everyone scrambles to comply with the current version of the law, subject to passage of Prop 24, we're going to have to pay attention to what nuances and changes and differences exist so that you can plan accordingly. I've been going around to lots of companies and professional service providers and essentially trying to educate them on some of the basics of the CCPA. I'm going to try and do the same thing here today. And, you know, the way that I think about things in the current environment, it boils down to this idea, and that is, I believe that there is a new sheriff in town, and her name is privacy. And we're all going to have to sit up and pay attention. It used to be that privacy was something that the European Union did through the GDPR, and they were zealots about protecting personal information, and that was not anything that was really going to have an impact on companies here in the United States. And over time, that has changed, and it continues to change. And I think that the CCPA, although it is a state-based statute and piece of legislation, the reality is that now the federal government is sitting up and paying attention. And in all probability, in the near future, we are going to see federal legislation that mimics in large part what the CCPA and potentially Prop 24 and the CPRA, California Privacy Rights Act, which may in fact pass through Prop 24, the impact it is having on a nationwide status and how all these different states are going to have to comply. Whether or not federal legislation passes remains to be seen. There is a legislation currently being bounced around called the Data Safe Act in DC, and that in large part, I think, has been influenced by the CCPA. So I think learning about it is not only important for companies who do business in California, but for companies all over the country who want to have a better understanding of how they are going to have to behave in the future. So there are three things that I want to talk about. I'm actually, hang on just a second, Pooja. I want to set my timer for 30 minutes because I love to hear myself talk and I'll drone on way too far otherwise. So there are three things that I want to talk about, or at least touch on, and we won't go down to the nitty-gritty essence and details of the act or all of the amendments, but we'll try and give you an overview so that you feel empowered with enough information, at least to be scared, and then potentially have a conversation to allay those fears. But the first thing is consumer rights. That's the essence of the CCPA. It is, from an objective perspective, trying to create a level playing field, or at least infuse a bit more fairness into the way that we as individuals have potential control over the information that we share through a website, through a mobile app. And for many of the companies in hospitality, it is not just basic information, personal information like our name, rank, serial number, but also highly sensitive information like credit cards and things of that nature, financial information. And so that's one, consumer rights. The second thing I want to talk about are some of the basic business obligations that we now have, or our clients have, through the CCPA in order to bring ourselves closer to compliance. And the third is just a few things that we can do to take steps in the right direction. I mean, there is so much that will evolve in privacy law and privacy law compliance over the next few years. I think it will be impossible for everyone to bring themselves up to speed instantaneously, but to integrate an understanding of what information your companies are collecting, how you're managing it, who you're sharing it with, whether or not you're selling it or monetizing it, all of those things from a basic level will help us take steps in the right direction. So that's a brief overview of what we're going to talk about. I want to try and contextualize for everybody the reason that the CCPA came about, because I think at the end of the day, looking at the statute is great and you will be better informed as a result, but understanding the underpinnings, the background, the history of why it came about, I think is going to be even more informative, because it will give you the ability to sort of relate the statute to your practice or your business. There are two triggering events essentially that I want to talk about. The first is Cambridge Analytica and the 2016 campaign and election, which is sort of timely because next week we're all voting as well. So in 2016, Cambridge Analytica, which was a UK-based political consulting arm, essentially hired a Soviet-born developer to create a software program that it launched into the social media platform Facebook. And it launched it and essentially released it to all of the Facebook members, and it offered each of those Facebook members a payment for downloading their software, which is highly unusual. It's usually either you're getting something for free and you enjoy the service, or you're paying for it or paying for premium services. But here it was flipped, right? It was the company paying for a download. So not surprisingly, 300,000 Facebook users downloaded this software. And in the disclosures that were made by the company in its privacy policy and its terms of service, it essentially said, here's what we're doing, here's what we're about at a very high level. And oh, by the way, we may collect some information from you, and we may collect some information from your friends. And what ended up happening through the software program, in only 300,000 downloads, they accessed the profiles, personal information, and data of 87 million Facebook users. 87 million. In 2016, there were 157 million registered voters. And if 87 million of them were those whose information was shared with Cambridge Analytica, at that point, you had a political consulting arm that had access and ability to influence news feeds, information, and anything else under the sun for all of those Facebook users, many of whom, most of whom, a super majority of whom had no idea their information was even being shared. So that was triggering event number one. It made people, not just in Congress, but around the country and around the world, sit up and pay attention to privacy, not for the first time, but for a first time in a meaningful way in the United States. That's event number one. Event number two is a guy by the name of Alastair Mctaggart. And Alastair Mctaggart is a very wealthy real estate entrepreneur in Northern California. Made a ton of money building his real estate empire, and was wondering what he was going to do with the next chapter of his life. So he decided to sit down with a Google engineer and talk about Google, fascinated by how powerful the company was and its brand, and curious to know how it did what it did and what kinds of information it was collecting. After he got through with that conversation, he was just appalled by what Google was doing with its algorithms, with artificial intelligence, and with machine learning to create profiles on the billions of people in the country and around the world that were sort of not necessarily clear about the amount of information they were sharing with Google and its partners, and yet came to rely on this search service as the most integral part of their online experience. And so very discomfited by this conversation, Alastair Mctaggart set out as his own privacy evangelist to try and fix the problem. And what he did was he drafted the CCPA. He drafted it. And he took it to Sacramento in Northern California, and he said, here is the statute that I need you to pass. And I'm giving you an opportunity to pass it. And Sacramento said, no, thank you. We love all the things that the big tech lobby does for us. We have no interest in passing a piece of legislation that is going to offend them deeply and to their core and potentially upset their business models. And so we appreciate you suggesting this, but no, thank you. Alastair Mctaggart was going to put that statute in its then current form in 2018 on the ballot. And what ended up happening was this. He went back to Sacramento and he said, if I put it on the ballot and it passes by way of referendum, then what you are going to have happen is a piece of legislation adopted by all of the consumers and voters in the state of California, which you will not be able to materially amend, right, in a way that is distinctly different from its purpose and its underpinnings. And so Sacramento, wanting control over the legislation, passed it in 2 weeks, thinking strategically, this makes sense. We'll allow big tech to lobby us and change the statute in a way that conforms to their expectations. So that's what they did. They passed it in a 2-week period of time, and then big tech, lo and behold, started chipping away at it. And that's why you have Prop 24 next week. Prop 24 is an amendment to the CCPA in its original form. Alastair Mctaggart does not want it to go away. He does not want it to be suffer deterioration as a result of the big tech lobby. He actually consulted with big tech in coming up with some of the amendments in Prop 24. And so as a result, he got 900,000 signatures, put it on the ballot. Sacramento wasn't going to pass the CPRA or Prop 24. And so in all probability, it will pass. And you will have as a permanent fixture in California, what I think is probably the most robust privacy, data security, and data collection law in the country. And it will heavily influence not just DC and its current negotiations about what to do for the country, but also on a state-by-state basis. And then the question becomes, is the federal law that they will probably pass in the next few months going to ultimately preempt California, or is California going to remain sort of the gold standard? I think it's probably the latter. So those are the two triggering events. Beyond the triggering events, I think one misconception that people have about privacy, especially online, is it's something I don't need to worry about unless I sell information, right? If I'm collecting it and I'm selling it, sure, regulate me, and I'll make sure that I make certain disclosures to the people who I'm collecting it from. If I'm generating revenue as a result of sharing it with third parties, that makes perfect sense to people, and they think that they are exempt based on the fact that they are not, quote unquote, selling that data. The CCPA is not just about the sale of personal information. It is about the mere act of collecting and or sharing that information. And in fact, one of the things that Prop 24 does, because big tech ended up saying, well, you know what, we're actually exempt from this law too, because we don't sell the data. We just share it with third-party advertisers, and then they bid on it in real time. So we're making money indirectly, but we're not selling it. And so in order to avoid those kinds of ambiguities from the first iteration of the law, the amendment covers not just selling, but also sharing, and covered entities that merely collect and use information for internal purposes may still in fact be covered by the law and may have to change the way they do things internally as a result of the mere act of collection. And the scope that I'm talking about, the kinds of information that could potentially trigger liability, is literally anything under the sun. It is the straightforward and simple things like your name, your email address, your phone number, basic data points about who you are, where you are, and what you do. Of course, that's personal information, but it goes beyond that. Facial recognition right now is becoming a hotspot. So companies like Facebook that are using it just to enable people to understand who's in a picture, that is now deemed to be personal information under the CCPA. And so you not only have to be transparent about the fact that you are collecting it, data points through software about someone's facial features, but how you are using it, who you are sharing it with, and potentially give people the opportunity to opt out of you making use of those kinds of data points, facial recognition software. They just had a big case in Ohio whereby, you know, companies used to license this kind of software to police stations so that they could create databases and identify criminals through facial recognition. But now it's becoming much more commercialized than that. Social media is deeming this to be a very important part of their business model. And so it is going to evolve in ways that were unanticipated, I think, in the first iterations. The other thing that I think is really compelling about personal information under the CCPA, it is all of your data, including your browsing history, your search histories, things that you do online that contribute to an understanding, not just of companies that collect your information, but of advertisers that they may end up sharing it with, the profiles they create based on where you visit and the news articles that you read and the things that you buy, all of that information, the profiles that's created, also personal information, and inferences that can be drawn from that profile. Because in essence, people can know very distinctly who you are, even if you don't end up filling out a registration form, right? It used to be that IP addresses were dynamic. So if I signed in to the web through my laptop, It would be different, and my IP address would be distinct if I signed in through my smartphone or through my iPad, right? Each a different IP address. But now IP addresses are mostly static, not dynamic. So if that IP address that's part of your household is being used over and over through multiple devices, all of the information can be aggregated, gathered, analyzed to create a very clear profile of who you are, what your interests are, what you might be reading and buying without you ever having filled out any information, right?
In the context of food and beverage, for example, if you've got consumers that are looking at an online delivery platform and they're, basically could the content of their food order also be considered personal information?
Absolutely. Absolutely. The content of the order itself as a standalone item, like the lists of items that you order from a particular restaurant, don't necessarily constitute personal information. But over time, if you enter information, if you place a bunch of orders and all of that data is aggregated to try and understand when you order, who you order from, what your cultural interests might be, all of that stuff can get folded into your profile. And so the individual pieces of information along those lines, less compelling than what they do with it in terms of aggregating it and understanding who you are and what you're doing. I'll give you an example of personal information that many of us are unaware of, but that is really compelling and disturbing. Geolocation data, right? The fact that we can be tracked through our smartphones in and of itself is personal information and covered under the CCPA. So one of the things that health insurance providers do is they will use information that they glean from geolocation data to determine, one, how often you go to the gym. And if you go often, you might end up getting a better premium from a health insurance provider than if you don't go to a gym at all. How often you go to restaurants that may or may not be good for you, right? They'll be able to distinguish between restaurants that are health and wellness oriented and restaurants that are fast food oriented. And so all of that data, incredibly compelling and powerful, not just for advertisers, but for companies like health insurance providers that want to make sure that they're calibrating what kind of risk you are. So it is the extent of the personal information that is being gathered and analyzed now is exponentially greater than anything we've ever seen in history. I was in a presentation, making a presentation earlier this week to a group of M&A professionals. And one of them said, oh, come on, it's always been like this. You know, we've always given up certain information to people who are in the radio or TV broadcast business, and they've used it to serve up ads. And even in the early stages of the web, it's all the same. And I think nothing could be further from the truth. The way that information has now come to define us in the most detailed ways has converted us into currency. And it really wasn't like that. Before, we cast a wide net and we didn't know exactly who we were communicating with, or at least the advertisers were communicating with. It's very different now. You can pick and target exactly the kinds of people you want to reach and influence. And so I think we have to keep that in mind as we move forward, especially in this industry. Okay, from my standpoint, this is like a consumer bill of rights, right? Like I talked about in the beginning, it is really empowering the individual in many ways, and it's burdening the companies, frankly. But the individual is now going to be flexing muscle and exercising rights along the Privacy Bill of Rights that was outlined by the Obama administration. First, they will have a right to communicate with restaurants, hotels, anybody in the hospitality business, or any other companies that might be covered by the CCPA, and ask that that company disclose to them the information that's being collected on them, the categories of that information, the specific pieces of information, the sources that those companies are gathering the information from, and both the business purposes and the commercial purposes, right? The business purposes are, well, yeah, we just collect this information and we make use of it for ourselves, right? It's all internal. It gives us a database of clients that we can now maintain an ongoing relationship with, right? No commercial component, no revenue generating elements to that. However, especially in a business like restaurants and hospitality and hotels, you really take the basic data that you collect for business purposes and you often convert it into commercial purposes, right? Because you end up sending out marketing-oriented email communications or text messages to your client base. And so you've now taken something that is purely business-oriented and internal and used it to monetize that relationship. So those two components have to be disclosed, right? And individual consumers have the right to know how it's being used.
In some context, Jeff, like hotels and restaurants may not even really be consciously thinking of this as a purpose to disclose, right? Because it's so part of, you know, building your word of mouth, having a newsletter, things like that. Maybe that it might not be something that you would think of as being a commercial purpose. So I think that's a really interesting point.
I think that to me is the scariest part of this next phase that we're all going to be going through. And that is, for so many years, we relied on this overly simplified, static hypertext link on a homepage that said privacy policy, right? And executives at restaurants, hotels, and other kinds of companies did not really pay much attention to it, right? They don't care about it. Like, get my website up and running so I can have, you know, a presence online and I can start to establish relationships. The old way of thinking and the passive way of approaching privacy through privacy policies like that is gone. It is a thing of the past. You have to start taking action internally with your chief technology officer, with your IT service provider, with your data security service provider, with anybody who's hosting your site, who is a part of the digital infrastructure, allowing you to collect information and start to understand what information you're collecting and where it's going, so that you can verbalize that, articulate it in an updated privacy policy, and then be able to act on all of the rights that consumers are going to be exercising when they email you or call you to try and find out what you're doing with their data. So yeah, I think there is a sea change afoot in terms of how companies have to deal with collection, management, and ultimately accountability as it relates to the personal information of their consumer base. One of the things that consumers are also entitled to is specific notice. It used to be okay just to give them general notice, like, hey, if you're interested, go read our privacy policy, which no one ever did. Now, at the point of collection, if you're about to collect data from them, you have to let consumers know, right? So they're entitled to know what information they're about to enter is information that you are going to collect, keep, and make use of. So you have to be much more proactive. They have a right, consumers, to tell you as a company to stop selling their data. If you sell it, and potentially, if Prop 24 passes, if you share it with a commercial component, they have the ability to say, no, I don't want you to do that anymore. And in its simplest version, website owners and operators need to have a do not sell button on the homepage, but it's going to evolve into much more than that. Like the GDPR, now California consumers have the ability to say, delete my information. Don't make use of it anymore, right? A right to be forgotten is the way that they refer to it in the European Union. And so that's something else that is not just an abstract concept. How do you go about deleting your information from your systems? You know, one of the exceptions to that rule is if you need it to complete a transaction, right, you can keep the information, right? Otherwise, you can't complete the interaction. So there's certain subtle changes and exemptions that will allow you to continue to make use of it and potentially say no, but you certainly have to take steps towards an understanding of all these new rights that are going to be exercised. They have a
quick question. So I see that some of our participants are part of groups of associated companies. For example, they'll have a hotel, and each different hotel that the group owns could be its own LLC. When you talk about restrictions on sharing information for commercial purposes if each company is its own LLC, but they try to gather data in a centralized way? Would that be considered sharing for commercial purposes, or is there some kind of exemption for related companies?
So if you are sharing with affiliated companies and it is not it doesn't have a financial component to the share where one affiliate is compensating the other directly for the sharing and disclosure of information, then no, it won't necessarily be a commercial purpose, but nonetheless, you need to disclose to the consumer that you have these relationships. You have to name every single entity by name? No, but you have to describe in general high-level terms, this is the corporate infrastructure that we operate within. We collect information through our websites and this brand. We also collect information, or our affiliates do, through affiliated brands. So we as the collector share with them, and they as the collectors share with us. So there is transparency. That really is step number one, educating the consumer on what's being done and who it's being done with. And then finally, the last right that I want to hit on is the right not to be discriminated against under the CCPA. So in essence, this is a right that it requires that companies who are actually making commercial use of information don't end up discriminating against those consumers who exercise their rights under the CCPA, right? Because then it becomes punitive. If you let me use your personal information in the way that I want to, and I get to sell it and share it and monetize it, great, you have access to all of my services, and I will treat you as well as I treat any of our consumers. But if you try and bifurcate that scenario and punish or limit the consumers who are exercising these rights, their ability to access your product or service or make full use of it, you could end up discriminating against one category who's not interested in sharing and giving all of the benefits to those who do share. Now, one of the concerns that consumer advocate groups have right now is that ultimately you're going to see companies paying consumers to access their information and and allowing, in addition to that, allowing consumers to pay for a heightened level of privacy. And that too can create a discriminatory environment where those consumers who can afford to pay for privacy end up with, not having to deal with all the advertisements and sharing with third parties and revealing all of their intimate details to the world. And then another category of consumer who is sort of forced to allow sharing in order to access this service and ultimately ends up, giving away the farm to all of these different third parties that they didn't want to have any, digital relationship with. So that's something to be aware of as well. Those are the consumer rights. One thing to keep in mind when, I was on the phone with a client 2 weeks ago, and they're in the travel business, and they feel like nothing is going to change. They'll go ahead and they'll make edits to the privacy policy, and they'll listen to me about things that they need to do internally. But mostly the CEO and the CTO are saying, you know what? No one is going to be exercising these rights. Like, I see it in the statute. No one is going to call us or email us. One, I think that that's not true. And if it's true, it's only going to be for a short period of time. Two, you better have internally employees trained and a process in place where you can verify the identity of those incoming inquiries. Because what is going to end up happening, a trend that will develop, as is always the case, is that plaintiffs' lawyers will latch on to facts and circumstances that benefit them. They'll have one isolated incident where one consumer ends up having their information compromised. It exposes a company's lack of compliance. And then you've got a huge class action lawsuit being filed, right? Because they'll be filing on behalf of one set of facts and circumstances that relate to an individual, and it relates to everyone else who could have been affected by the law. So one thing to keep in mind is proper training internally, be prepared, even if it doesn't scale up quickly for that plaintiff's lawsuit, and then have a verification process in place so that if someone does exercise rights, you as a company have the ability to make sure that that person is who they say they are. If you end up giving access to personal information to someone who says they are a certain person, but they're not that person, and you haven't taken the steps to verify it in much the same way our banks do that before they start doling out information about our accounts, then you're in trouble as well. So whether or not it ends up resulting in this huge influx of consumers exercising their rights, in my mind, is irrelevant. You have to take it from a defensive standpoint, a defensive posture, so that you minimize the risk of those kinds of violations. Those are the private rights of action, the individuals and the plaintiffs' lawyers, but you also have to be aware of the governmental level enforcement rights, which are currently residing with the Office of the Attorney General, right? But the Office of the Attorney General, who sent out like 60 notices to companies that had consumers complaining about them and what they were doing with their information, and the fact that the consumers believed they weren't in compliance with the CCPA. Those notices went out, but under the CCPA, there is an opportunity to cure, right? So Office of the Attorney General, the OAG, sends out the notice, company gets notice, they contact outside counsel, within 30 days, they fix the problem, right? No fines. If Prop 24 passes, there is no opportunity to cure. So you're not going to have the same flexibility and ability to limit liability that you do now. So at a minimum, we should use the next couple of years as a training ground, being aware of, one, private lawsuits, and two, enforcement actions coming out of the Office of the Attorney General. But three, if Prop 24 passes, they will essentially create a fully dedicated privacy-related agency in California that will be staffed with 40 full-time employees targeting companies who are not complying. To give you a frame of reference, the OAG's office has 2 people dedicated to privacy law enforcement as compared to 40 when the new law passes. And 40 is about the same number that they have at the FTC dealing with the country as a whole. So it will be something that will become increasingly relevant when and if Prop 24 passes, but something we have to pay attention to regardless. Okay, in terms of data security, I was talking with Pooja about this yesterday. You know, the CCPA is heavy on privacy and light on data security, but you still have to pay attention to data security, and it is an element of the CCPA. Privacy is, that's 30 minutes, just so you're aware, Pooja. Privacy is something that relates to information that we're collecting, how it's managed, who it's shared with, and whether or not we're monetizing it. And data security, a separate category, how are we protecting it, right? And the CCPA is relatively simple in its language. We need to have, quote unquote, reasonable security in place based on the kinds of information that we're collecting. So I think something that's really important for restaurants, hotels, people in hospitality to be aware of is the CCPA, as it will be amended by Prop 24, is going to bifurcate information into 2 categories. One will be general kinds of personal information, and the other category will be quote unquote sensitive information, right? And that's what hospitality collects: the financial information, credit card information, travel related information, all of these intimate details about who we are, what our age is, and potentially, I don't know if health information is collected, but you can glean certain health information from how we dine and who we're dining with. So all of the sensitive information needs to have a much higher level of data security, right, than generic kinds of information. So what does reasonable mean? It depends, right? That's the classic lawyer answer. It depends. So if you're collecting sensitive information, you better have the most robust sort of data security in place to protect it if you want to minimize liability under the CCPA. The other thing that you have to do automatically, and I would be shocked if any of the people listening in on the webinar today aren't doing this already, but you know, it's possible. You have to be encrypting and or redacting all of your information so that at a minimum, if there is an incident, right, if there's a data breach, that you can claim you, 1, had reasonable security in place, and 2, you're not liable because they got away with data that they cannot understand. It's encrypted. So unless they get both the data and a de-encryption key, right, then you're safe for the most part. Although we can talk more about that a little bit later, Pooja, because there are lawsuits that are being filed that are sort of undermining that security. Okay, so I'll say one last thing, Pooja, and then we can transition into the next part of the presentation, and that is the businesses that are affected. Okay, businesses that are affected, there are two prongs to pay attention to. The first prong is, do you collect, share, or sell information? In my opinion, don't even pay attention to share or sell, right? Do you collect it? And based on the categories of information that I was describing to you earlier, I can almost guarantee that every single company affiliated with our client base is collecting the most basic personal information. So that's prong one. Do you collect? Are you collecting it from California consumers? Right now, the law governs California citizens, right? California residents. And so you don't have to be a California company to be a covered entity under the CCPA. But if you are in Michigan, Florida, New York, and you are doing business with a California consumer, that consumer is protected under the CCPA. That's prong one, okay? Prong two, it's one of three things for prong two. If you make more than 25 million bucks a year and you collect under prong one, you're covered. If you are in the business of selling personal information, meaning you generate more than 50% of your revenue from the sale of personal information, you too are covered. The Prop 24 and the CPRA, the amendment, is going to change that. It's not just going to be 50% sale, it's going to be 50% of your revenue is the result of either selling or sharing in its next iteration. And that's not the catch-all. The catch-all for me is this last part of prong two, and that is, do you collect personal information from at least 50,000 consumers for commercial purposes, right? And the reason I think that's important is twofold. One, it's going to change and get bigger in the next version of the CCPA. So when this amendment passes, it will be 100,000 consumers, but they'll do away with the requirement for commercial purposes. Right now, if you are somehow monetizing the information you're collecting from 50,000 consumers per year, then you're covered as well. So,
and Jeff, what would that mean in terms of an app? If a company has an app, how would they know if they're monetizing it? Is it that they're monetizing the personal information? If they're collecting information and having people register for an app and they have 100,000 users, what would that line be of whether that information is being monetized?
So the easy analysis is, are they sharing it with anyone and receiving any money in exchange for the share, right? So if it's third-party advertisers they have a relationship with, that's easy, you're monetizing it. The more subtle and I think challenging analysis is, if we collect information and then we market our services and we actually land consumers through the marketing of our services, and they make a reservation in our restaurant and they sign up for a week-long vacation at one of our hotels, is that monetizing for a commercial purpose the personal information that we're collecting? I say yes. We may have to wait until there's some case law in place, because often the statutes as a standalone don't give us flesh on the bones. But I would imagine that any company that is using personal information to actually market services and sell services to their consumers are potentially triggering that component of the prong. So there are other things that I can hit on, Pooja. I can talk about, the fact that there are all these loyalty programs that lots of restaurants and hotels have in place. I think it is really, really important for those companies to evaluate whether or not the financial incentives or the loyalty programs are in compliance with the final regulations promulgated by the OAG's office, because some of the ambiguities in the statute left open further analysis by the OAG, and they've essentially given examples now of what constitutes a legitimate, fair, and reasonable financial incentive or loyalty program, and what programs might be deemed discriminatory. So that's something very important for your client base to keep in mind. Some other things, the last part of what I wanted to talk about is just a few things to keep in mind in terms of moving forward. So steps you can take. The first thing is, do a gap analysis and a data inventory, right? So that you work with technology people, the group that I described earlier, your CTO, your IT services, your data security, to understand where you are collecting information from, what the information is, what you're doing with it, how it's stored, how it's secured, so that at a minimum you have a basic understanding of what needs to be included in an updated privacy policy. Gap analysis, data inventory, step one. Step two, if you as a company rely on third-party service providers, and we all do, right? We focus on our core competency, and then we sign deals with all of the specialists. Again, IT services, data management, web development, web hosting. If you are sharing information with any of those third parties, they too need to be in compliance with the CCPA. So you need to make sure, one, that you have that conversation with them. Are you or aren't you? And two, whatever the standard engagement agreement is between you and your third-party service providers, you need to look at it and update it, right? There's got to be an amendment that says, hey, we need to allocate responsibility here. One, a new rep and warranty in those agreements saying, yes, third-party service providers hereby promise, represent, warrant, and covenant to comply with the CCPA in all these ways. And two, if we don't, here is the penalty, right? We indemnify you, the restaurant, hotel, or other company against any damages you suffer as a result of our misconduct. So that's one. The other thing to do is look at your insurance policies, right? Make sure that at a minimum, you have cyber insurance in place. And two, actually read the policy and talk to your broker to make sure that it covers both breaches, which is sort of the standard go-to if you suffer a breach for these reasons and you've acted reasonably, we, the insurance company, step in and defend you, but also covers privacy, which again, two different categories. One, adequate and reasonable data security, and the other is privacy law compliance, and how are you acting in this new era where the CCPA governs what you do, what information you collect, and how you deal with your consumers.
Sounds good. Jeff, I wanted to, because we're going to give attendees a chance to get this, I wanted you to describe the business guide to the CCPA briefly, and then we'll touch on it slightly at the end. But Jeff has prepared a business guide to the CCPA that we will be providing if you send us an email. So could you just describe a bit about what that is?
So the business guide to the CCPA is sort of my condensed version of the statute and potentially some of the regs promulgated by the OAG, just to give companies a snapshot and a 30,000 foot view of things they need to be aware of. It somewhat tracks and highlights the way that I've been talking about it today, but it is a starting point, and I've tried to draft it in layman's terms because looking into the statute and reading and analyzing it is one for lawyers and two for the birds. So that's really what the guide does. It's sort of in a 5 to 10 page scenario, gives a snapshot, and then there is a sort of this graphic representation at the end of it that shows whether or not your company is a covered business.
That's great. So I wanted to talk for 5 minutes about the ADA, and then I wanted to end our presentation by just talking to Jeff about a couple of recent incidences in the industry that involve data breaches and kind of what we could learn from them and how the CCPA might apply. But one issue that comes up a lot for places of public accommodation, and that's both restaurants and hotels, is ADA compliance. And anybody in the industry who actually operates a physical location and is a place of public accommodation is very well aware of ADA requirements in terms of space and how you construct your property and your parking requirements and bathroom requirements. And as we all know, there has long been a plaintiff's mill of kind of ADA cases. And I'm sure anybody who operates restaurant locations or hotels has had a situation or heard about situations where you get a letter in the mail from a plaintiff's lawyer asking for essentially a nuisance settlement and to fix part of your property. The industry is very, very, very familiar with that. So the trend that's been happening recently, and it's happening all over the country, but particularly in the Ninth Circuit in California, is that ADA compliance is being extended to require accessibility for your website and for your app. And this has been a new development. This is something that plaintiffs' lawyers have been coming at for the past few years. Keep in mind that the ADA was passed in July of 1990. So at the time that it was passed, there's no explicit references to websites and definitely not to apps because it was 1990. But there is a reference in the ADA to auxiliary aids for accessing places of public accommodation. And courts have found that the website and app is an auxiliary aid. Now, in last summer, there was a large lawsuit involving Domino's that went to the Ninth Circuit, and essentially a visually impaired customer had issues ordering pizza through the Domino's app. And anyone who's ordered Domino's knows that Domino's spent a lot of money developing that app. So they were, and the app is not compatible with e-readers or assistants to help people who are visually impaired. It's just the app was not designed to be compatible with that. And Domino's took the case to the Ninth Circuit, and the Ninth Circuit found that because Domino's, the restaurant locations were places of public accommodation, the app had to also comply with WCAG accessibility standards and be available to customers who had disabilities that prevented them from using the website without reliance on their e-readers. And so this applies broadly. And the Ninth Circuit and California state courts have found that there's this accessibility requirement for both websites and apps under the ADA and under California civil discrimination law. So I've been seeing a large influx in restaurant clients getting served with demand letters based on the design of their website or their app. For the most part, restaurants have fairly simple websites, and especially if the restaurant is not big, a lot of times it's not a priority in terms of development. But now I think more and more restaurants are starting to build their web presence because it's necessary to operating in the pandemic. And so it's one thing that I've seen a lot. I think this is the new kind of ADA nuisance issue to be looking out for. So if you're developing your website, and even if you're not, it's worth taking the time to see if your website is compatible with the WCAG guidelines, and if not, to invest in a consultant for that. There are several services that will do it for a reasonable amount. And if you're already in the process of designing your website, it's definitely something that's worth doing. I mean, some things that are part of complying with the WCAG is essentially making text alternatives for images and designing the website generally in a way that's compliant with that's compatible with these screen readers. That's all I'll say about the ADA. It's not a great topic and it's not a great development, but it is something that can be one of those little nuisances. And if you don't address it now, you just don't want to deal with a plaintiff's lawsuit. And I'm telling you that there is a wave of those lawsuits coming, and it's something worth keeping in mind.
And Pooja, I wanna pick up on something that you're saying as it now relates to the CCPA, and that is these nuisance lawsuits. So it's happening on a bigger scale. Not that many letters have gone out threatening a lawsuit and offering to settle for $3,000 or $4,000. That has been the trend with failure to comply with the ADA laws. But under the CCPA, one of the things that the plaintiffs' lawyers are doing is, even though enforcement is supposed to be reserved for the OAG, they are filing lawsuits on behalf of individual consumers and saying, one, violation of the statute. And if it were that alone, it would get kicked from court. But they're also saying, because of the violation of the statute, these companies are engaged in unfair business practices. And that is a state law claim, and that is going to keep those lawsuits alive. And so the nuisance won't come in the form of a letter. It'll be a lawsuit ultimately that insurance companies get involved in, and there'll be settlements. But same thing is happening because the violations under the statute for privacy related violations, anywhere between $2,500 and $7,500 per consumer. That's a lot of money per consumer. Violations of data security, smaller, between $100 and $750 fines, but again, per consumer. So if you've got data from 1 million consumers, you have a huge statutory violation under either scenario. Sorry to interrupt.
No, that's great. I think that brings me to how I wanted to end the presentation, which is I wanted to just talk about a couple of recent things that have just happened this month in data breaches and privacy that involve our industry, food, beverage, and hospitality. So on October 16th, just 2 weeks ago, Dickey's Barbecue, which is based in Texas but has 156 locations across 30 states, they found out, the way a lot of their consumers did, about a massive breach of credit card information. So 3 million payment card information, the payment information for 3 million credit card users was found on an underground marketplace and on kind of a dark website that sells this kind of consumer information. So that's a massive breach. I think that the first time that Dickies found out was when it was actually posted on that website. So under the CCPA, what obligation does a company have in this situation, and what consequences, if the CCPA had applied in this case, what consequences would this company be looking at?
So I think it's important to keep in mind that laws vary from state to state, right? So the CCPA at its core covers California consumers, so it may or may not apply to the Dickies breach. If it does, then our analysis is, was there reasonable security in place? That's from the CCPA standpoint. But there are so many other statutes in play that you really need to take a look at some of the obligations created by the PCI DSS guidelines for credit card related transactions, and those companies that collect that information, much higher standard and much more detail in terms of obligations than is articulated in the CCPA. But at the basic level, no matter where the data breach is occurring, state to state, you need to get parties involved internally and externally, meaning your counsel, to evaluate what happened. Was there an actual breach? Was encrypted or de-encrypted data or the key stolen? How many records were potentially compromised? I think if you don't have a data security service provider, get one in to sort of track along the network what happened and to plug up holes, right? Because when you hire an outsourced provider, they help you not only identify what happened, but also remediate, right? So you need to be able to remediate what's going on your network, because if they got some, in all probability, they're going to go after more. And then once you've taken those sort of first tier steps, evaluate whether or not you need to disclose first to the state-based agency regarding the breach, and two, whether or not the law requires you to actually communicate with the consumers whose records may have been compromised. You don't just run to the last step and let everybody know, including the consumers, that there was a breach. You methodically approach it first internally from like a business preservation, data preservation standpoint, then evaluate whether or not you need to consult the government, and then determine whether or not you need to take the step of communicating with your consumers. And ultimately, I think consumers recognize that breaches happen. And so if you are focused on maintaining the value and integrity of your brand, treat privacy in that way. You know, when errors take place, take responsibility, be communicative, be transparent, and help, put consumers in a place where they can know about the compromise, they can cancel credit cards that they may have used with you, they can monitor their credit through Experian or Transmedia, and I think that way they stay a good consumer or customer for you.
Yeah, as you can see, this is a really rich area. I think Jeff and I could have this conversation for another hour, but we want to keep this on schedule. So we'll end here. Thank you everyone for attending. And Jeff has published that great guide, that great business guide to the CCPA that really goes into detail and is really well written for a layperson to read about what your obligations could be and when the CCPA will affect your company. So please reach out to us by email. I think we'll put up that screen that just shows our email addresses and LinkedIn. Please feel free to connect with us and ask and send me an email if you are interested in getting that guide. Thanks everyone for attending. We will be hosting an end of the year event in December, which will be a food and beverage and hospitality industry trends kind of year-end review and a preview of 2021 for the industry. And you can look for information about that from us. We'll email you that link. That'll be our next event. Jeff, thank you for your time and for providing so much great information on this important issue.
Oh, Pooja, thank you for having me. I enjoyed being here.
Yeah, this was really interesting. And I think especially this is going to be something that everyone will need to be concerned about. So we'll see what happens with Proposition 24 next week. But I think this is already going to be a lot of, even startup companies with that 100,000 mark could really be thinking about this for the future.
I agree with you. And I think of this this era that we're involved in as one that it's like a moving target, and it's becoming increasingly more important. and evolved and complicated. So the CCPA is scary enough. The CPRA will be slightly more scary. And if you really want to be scared, take a look at The Social Dilemma on Netflix right now to see what the former engineers from Google and Facebook think about privacy as it relates to artificial intelligence and machine learning. That way you won't go to sleep at night.
Great. That sounds like a rave review, but it actually does sound really interesting. All right, thank you everyone. Thanks for your participation, and look forward to connecting with you on LinkedIn or hearing from you on email if you have any questions or would like to reach out to us about issues that are specific to your company. Thank you.
Great. Bye, everybody.